Today, I will be talking about succession planning and how effectively you can do your succession planning. Well, there are various methods in which you can do your succession planning. Depending upon your situation and what you want to do, you should accordingly plan yourself. If you are wanting to distribute your assets, whether it is movable or immovable assets, to your various close relationships in unequal proportions, then of course you will have to do a will. I quickly mention the most important points that you must remember while you create your will. The first one is that for will, you must have an executor. An executor is a person who you trust and who may be younger in age to you and who will be at a later stage when the will be getting probated, tell the court that you are the executor to the will and you will be administering the property. After the property is administered, then you submit to the court that all has been executed properly as per the requirements of the will. You would also need two witnesses to the will, persons who are again preferably younger to you by age, and one of whom could be preferably a doctor, so that the person, if required, can certify that you were of stable mind. Once a person expires, the will has to be probated by the court, in which case the executor gives the evidences, and if there are any legal heirs or beneficiaries to the will, they make representation to the court stating that the will is genuine and they do not have any counter claims. Once the court is satisfied, it gives an order which is called the probate. After receiving the probate, the executor can execute the will of the deceased person. Now, if a person does not want to make a will, that is, he feels that whoever is the heirs, they will have an equal share to all the movable and immovable property, and there is no unequal distribution required, in which case the person dies intestate, that is, without a will. The first class heirs, that is, the son, daughter, widow, and mother of the deceased, will be the class 1 heir, and they will be getting all the properties, movable and immovable, in equal share. If no such person exists, then the property will go to the father or to the siblings. One must note that in case of intestate succession, that is, on the application of the Succession Act, the law is very, very rigid. That is, it will not consider what was the relationship of the concerned relative with the deceased person. That is, if the deceased person had a very bad relationship with one of his sons or one of his daughters or the widow, that will not be considered and all the property will be divided equally. Again, if there is a child who has certain deformities or any son or daughter having any deformity, then also the division will be equal. The court will not say that one person who is disabled should get more than the others. Similarly, there is no question of any charity in case of intestate succession. In case of intestate succession, the other factor is that the court will appoint as executors administrators of the property. It may also be noted that in case of intestate succession, there remains a risk of partition suits being filed. In case of a will, the person creating the will has absolute control over the assets or the properties he wants to distribute. He gives the property as per his choice to the individuals whom he likes to give. One of the major disadvantages of both these methods is that in case of will also, it has to be authenticated by the court by way of a probate. In case of intestate succession, there has to be a succession certificate which has to be taken out from the court. If you are wanting to avoid any court interaction, then there is another method which is creating of a private trust. The trust is created under the Trust Act, and you give the property to the various beneficiaries that you create in the trust. You also create an executor to the trust, and you can create the various terms and conditions on which the trust is created. This way, you totally avoid the matter to go to the court. However, whether the particular trust will be more useful to you, or it should be a will, or you do not create any will depend upon the circumstances and your wish and your desires of the distribution of your property. But whatever you do, your succession planning would necessarily require that you keep in mind certain points. One is that you should list down all your movable and immovable property. Number two is that you must create nominees in all your bank accounts, demat accounts, as well as in your insurance policies. Number three, that you must always create joint accounts and not single account, and you should normally give a either or survivor mandate to these accounts. In case of immovable properties, clear off all your debts and liabilities from that property so that when you do your succession planning, it is a clean property that you pass on to your heirs. I hope these few tips for succession planning will be useful to you. Thank you.